Welcome to Law Talk Today, a series devoted to bringing you informative and educational programs focused on issues of law, government, and community. Hello, and welcome to LawTalkToday.tv. I'm Dan Agatino, your host. Joining us in studio today is Gretchen Rafuse, an associate at Gruber, Colabella, Liuzza, and Williams. Gretchen, thanks for joining us.
Thank you very much.
I wanted to talk with you today about expungements.
Okay.
It's a area of practice that allows people who have a bit of a history erase that history. But I know that there's some things that just can't be erased.
That's correct.
What are some of the areas that you can make go away?
There are certain things that we can expunge in the state of New Jersey, and the effect of an expungement is that the offense is deemed not to have occurred. So when someone who has had their record expunged is asked, have you ever been convicted of a crime? Have you ever been convicted of a criminal offense? Can answer truthfully, no, I haven't, because those records have been expunged. There are certain crimes, obviously, that the legislature has deemed significantly serious, that it's in the interest of society to keep a record of those offenses and people who have committed them. For instance, homicide, arson, kidnapping. These are just a few examples of some of the crimes in New Jersey that cannot be expunged. Some things that can be expunged are criminal mischief, which is a low-grade crime, or harassment. That sort of thing can be expunged. Disorderly persons offenses or petty disorderly persons offenses, which are not crimes but are considered offenses in the state of New Jersey and typically handled in the municipal courts. Things like that can be expunged. Violations of a municipal ordinance, they can be expunged. Let's see, if you've been charged with a crime and the prosecution has offered you entry into a diversionary program, such as the pretrial intervention program, and you successfully complete that program, you can expunge the record of your PTI.
So what does it actually mean to expunge a record? So let's say that I'm arrested, and then I come to you, and I say, I was arrested, I was convicted, and this was 5 years ago, and I want it off my record. It is not homicide or kidnapping or arson. It's just violation of, I harassed somebody.
Okay.
I said.
So if you're dealing with harassment and it's been 5 years, I assume that you're talking about harassment in the municipal court level, which is an offense, not a crime. There are certain time frames that have to pass before someone can petition the court to have a record expunged. The harassment that you just cited, a person has to wait 5 years from the final disposition of their offense before they can petition the court for an expungement. Essentially, what it entails to ask for an expungement of the court is you have to prepare a verified petition. And what that is essentially letting the court know I was convicted of this offense and this date in this court. This was my disposition. There are currently no charges pending against me in this state or any other state.
Related to that matter or anything?
Any matter, any matter. So the court wants to know that this was a one-time offense that occurred, outside the time frame that you have to go through before you can petition the court, and that there's currently nothing pending against you. What you have to do then is give notice to a variety of law enforcement agencies throughout the state, the Attorney General's office, the Superintendent of the State Police, the municipality where you had incurred this charge, if you had been arrested, any facility where you had been incarcerated. They have to get notice that you're petitioning the court for this relief. So you send the petition to the court, and the judge sends back an order to you. An order essentially fixes a time that he's going to hear your matter. Okay, so generally it could be anywhere between 30 to 60 days from the date that you send this petition to the court that you are assigned a hearing date. In that time, You're supposed to give a copy of this order to all these government agencies, and then it's their job to search their records to see if they can find any reason why they have an objection to this expungement. Perhaps you had a conviction for aggravated assault a year ago that you forgot about, and law enforcement discovers this. You're going to get a letter from the prosecutor's office to the judge that says, I'm objecting to this petition for expungement because there was a subsequent crime that hasn't been disclosed.
So are you saying you could only expunge one offense? What if I said to you, I was convicted 5 years ago of harassment, and then 2 years ago I was convicted of parking violations or something that's not really substantial, like arson and homicide, and you could expunge multiple.
You can expunge up to, I believe, 3 offenses, but for crimes you can only expunge 1.
Okay.
Okay, so they don't want people to commit a crime, get it expunged, you know, commit another crime, and then come back and get it expunged. Subsequent criminal convictions are going to be an absolute bar to expungement.
Well, what about criminal offense that is a compound issue? Like, I have clients who come in and they have a whole boatload of tickets. They got a full house, right? So they say, well, I was charged with, we'll move it out of tickets and say just 2C violations or criminal offenses. So I have harassment and I have assault because the harassment led to an assault. But then they were held at one court session, and can you get them both removed, or is that 2 separate strikes?
You could do 2 offenses at the same time, especially if they've arisen out of the same occurrence. And there is some case law that suggests that a certain conviction may arise out of one occurrence, even though it may have resulted in 2 convictions. But as long as you've met the statutory requirements for the time frame and you have 1 crime or the statutory number of offenses that can be expunged, you can expunge everything.
Okay. So I come to you, we're going to do the expungement, we send the notice to the court, papers to the court, and we send notice to all the agencies, and I get an objection. Can we object to the objection?
If there's an objection, the court may bring you in to have a hearing to discuss it, and they'll argue why they're objecting to this. And if you feel their objection is inappropriate or incorrect, the judge is going to hear you on that, and then he'll make the final decision as to whether he can expunge, your charges. However, the vast majority of expungements never even go to a hearing.
Okay.
Because if your client is honest with you and an attorney does their work and is diligent, and when they send that petition in, they are absolutely certain that there are no other offenses or crimes that need to be disclosed, there are no other bars to expungement.
Right.
Once all these papers have been provided to the court and the court doesn't receive an objection, by law, the judge is permitted to sign the order of expungement and distribute it to the attorney without anyone ever appearing. If there's no one to object to the relief, why bother appearing in the first place?
So the judge has the papers, there's no objection, or the objection isn't substantial, and she signs the papers. Now, there are agencies in New Jersey that keep a record of my conviction. They have to burn it?
No.
Shred it? Destroy it?
What happens is once we get this final order of expungement, we go back to those same government agencies and law enforcement that we had previously sent the judge's order to. We had to give them notice that we were going to have a hearing. They also are entitled to notice that our relief has been granted and the judge has granted the final order of expungement. What they do is, once they have that order, they will go through their records. Any record that they have relating to the offense or the conviction or the arrest or whatever it may be is removed from their general files, and it's placed with a custodian of records that specifically holds expunged records. And those records are not released to the public, and if anyone would go to that particular custodian of records,